welcome to Tort Talk. I'm Marc Rioux here with Jon Robinson and Joe Fantini. This week, a shocking $5,000 Uber verdict. The Bard PowerPort Bellwether kicks off in Arizona. A landmark Supreme Court argument in the Roundup litigation. And we're recapping the hottest torts from Mass Torts Made Perfect in Las Vegas. Big week. Let's dive in, Jon.
Coming off the heels of Mass Torts Made Perfect, Joe, there's a lot of news we're going to talk about that came out of that event, but also here it is next week, and we've already got other news to talk about. We had a verdict today, the second verdict in the Uber MDL. That second Bellwether, I think it was a defense pick, and the third overall Uber sex abuse case. The jury returned a verdict in favor of the plaintiff, but it was only $5,000. I know we had the common carrier issues that came up. What does this result tell us, being as how this was a defense pick?
Hello, it's Mark. Let me break in for a second because this one's worth mentioning. Jon and I are headed to Mass Tort Puerto Rico in a few weeks, and with it being the 5th year of the event, this feels like the version you don't want to miss, and then hear everyone else talk about later. We'll be there as the official podcast sponsor, recording episodes of the podcast on site at Mass Tort Puerto Rico. So stop what you're doing and go to masstortpuertorico.com and join Jon and I in San Juan at the lovely Condado Vanderbilt Hotel, May 5th through 7th. Got your tickets? Cool. Now let's get back to the episode.
Yeah, that's a great question, Jon. It pretty much tells you that this could be looked at from both sides as a win. A win-win for everybody except who I would say the individual plaintiff in this case. So we got in front of the jury what we always try. It was about a week-long trial, ended up coming back in favor of plaintiff, but only awarded $5,000. You know, I don't know all the specifics of the case, but the alleged assault that occurred in this case, the defense was really able to bat that down, and it involved maybe touching of a leg is what everybody seemed to agree upon. Not sure if it got past that, and the jury felt that Uber was liable for the conduct of their driver. That's pretty much what we've seen in all of the Bellwether trials, the 2 in the MDL, the 1 in the state court. But the damages just weren't there, according to the jury. So a little bit disappointing with the number. I think it's helpful for the plaintiffs because we know we can get over that common carrier hurdle, but it really shows us that you need to have that specific causation and then the real damage is there. So this isn't going to do much, I don't think, in terms of resolving globally. So we'll probably have another couple trials coming up, but each side plaintiffs for a win. You know, feel a little bit bad for the individual plaintiff. All they had to go through for this case and this trial to only get that amount, definitely disappointing.
I didn't even realize that unwanted touching was part of the MDL. I thought it was excluded.
That's what the kind of assault in this case was, you know, really limited. Maybe there was some more alleged conduct, but that's kind of what it turned on. I'm hearing that, you know, it wasn't as severe as the other cases we've seen. You know, maybe some sort of rape or more involved sexual assault. So I think that's what we're taking from that, along with being able to get over that common carrier. So not minimizing what the plaintiff went through. It was horrible. I think they deserved more. I think we all agree on that. But a win-win from both sides is how it's being spun.
Listen, any progress in these cases is good, especially when it's a defense pick. I will tell you already this morning, I've gotten people who have reached out to us looking to now acquire more cases in the Uber MDL, right? So to me, this is progress. It could have gone in the opposite direction. Yes, it could have gone much better, but I think this is just continuing the momentum of the past trial that we had. It's not a bad result, I don't think, again, for, you know, anyone other than, you know, potentially the plaintiff who maybe, you know, was rightfully owed a little bit more. And we don't know the exact circumstances of the case, but from a case acquisition perspective, I think this is, you know, it's just progress and how we see these cases go.
Yeah, it's a win at the end of the day. And so, you know, we won 2 out of the 3 trials. Even in the third one that we lost outright, came down to the specific facts of that case. So there's been other cases that have settled. So people are excited still about this litigation. It's not going to be a slam dunk runaway litigation. Uber's fighting like hell, but that's what happens in these cases.
with all of the news of all of the other platforms that have been involved in litigation over the past couple of months, Uber's sort of been flying under the radar. We saw the Lyft consolidation. We did have that other verdict, but then things kind of went quiet until the result that we had today.
Yeah, that's true. They're staying out of the news here, probably a strategy on their part. So we'll see how this goes, but still opportunity to get involved. A lot of people that need help. Always exciting when we get a trial.
All right. Speaking of trials, another mass tort trial kicked off this week in the District of Arizona before Judge Campbell. That's the Bard PowerPort trial. What are you looking for in this first Bellwether trial with a little over 3,000 cases pending?
Bellwether trials are always important, but the first one, that really sets the tone. So it's huge for the plaintiffs to come out and get a win on this first case. This is an MDL that's been going on for a number of years. We got good sides, we got good lawyers. Hopefully we get a good jury. That's what it's going to come down to. Expect maybe about a 2-week long trial. Not going to get into the weeds too much about what happened in this individual case. They should be able to pick a jury pretty quickly, and then we'll get right into it. So maybe by the time we talk next week, definitely by the end of next week, I think we'll get a verdict. Hoping for a plaintiff win. This is a plaintiff pick. Always getting the momentum started is hard. Getting to trial is very hard. And now getting the jury to believe and compensate the plaintiff appropriately, that's the next hurdle. I know you guys are really excited about this litigation.
I've been saying this for a while. I believe in this case. I don't think there's, a ton of numerosity there, as we've spoken about, depending on the injuries that wind up becoming, compensable. But I do believe in the lawyers behind it. I believe in the science behind it. And I think this case has some potential.
Yeah, I agree with you on that. So we'll have a verdict shortly. Hopefully we're celebrating that win.
Also, in other news, in Roundup, we have a huge day in the Supreme Court coming up on April 27th with the Roundup appeal. We do have the class action settlement in place. Why does this argument matter so much?
Yeah, this argument's huge. So there's the opportunity for people in the settlement to opt out, so not to participate. And if they do that, their case is going to go forward. And one of the main claims we have, and we've seen in all of these Roundup cases that have gone to verdict, is the failure to warn. So basically, the plaintiffs are alleging that Monsanto and Bayer failed to warn that using Roundup could cause cancer. And what we've seen in other cases, in pharmaceutical or medical device cases, is that these claims are preempted by federal law because the manufacturers couldn't change the warning. They couldn't change the label to add these things in because the label was approved by some regulatory authority. So here we're seeing for the first time whether or not the EPA has that same authority so that a manufacturer can't change the label on the warning. This has broad implications. We have cases going on in Paraquat, similar type theories. There's going to be other cases that come on down the line involving similar herbicides, but also think that this could impact what we have going on in hair relaxer and other litigations where the governing authority isn't the traditional regulatory authority that we see, the FDA, and whether or not now those labels cannot be changed. So it's going to have a huge impact, not only on the cases where the plaintiffs opt out, but also broader on the Roundup litigation and other litigations going forward.
Interesting. I did not realize all the connections that were being tied to that one decision.
It's an argument that we're anticipating the defendants making, and it's never been tried before. It's never really been argued. We've never lost that argument in some of these other cases, but it's going to have a huge impact right away on Roundup, and then also in Paraquat. They have a motion pending, but they're asking that the court hold it in abeyance until the Supreme Court ruling comes down. I think we're going to have a ruling this summer, probably the end of June, early July.
Do you have any idea or any hint of which way it's going to land?
Well, I'm hoping it lands in the plaintiff's side. We got some really good lawyers, right? Keller Postman is doing the main argument for plaintiffs. They're really experienced. The defense side has some really good attorneys too. So it's a conservative bench though. So I would say right now the scales are tilting a little bit in the defense favor. That's why people did this Roundup settlement, to have everybody in the settlement before the decision comes down. So I could see it both ways. It's going to be watched very intently, and I hope we can come through. And if we do, that'll be a huge win.
I love, Mark, how you're asking the great Fantini for his prognostication about what's going to happen in the Supreme Court.
Yes.
Like he's seeing into the future.
The great Fantini, also call him Joe the Oracle Fantini. We're still workshopping names. If you guys have any favorites, please put them in the comments.
Yes.
All right, moving on. We got some tea that everyone wants to know about. MTMP. It was a fun few days in Vegas. There's a lot of talk and whispers in the streets. What is everyone talking about, Joe?
Yeah, what I was really surprised about was the enthusiasm about Olympic scopes. We talked about it before heading in there. Thought everybody was going to be excited, but that was almost the belle of the ball. So it's rare that we have a pre-MDL case with that much enthusiasm and excitement. I was surprised by how many people are in on it. And that just brings me back to my glory days of mass torts when we used to sue about medical devices and pharmaceutical drugs instead of, dating platforms or chemicals in hair relaxers. So it brought me back in the day, when I was much younger, and it was the traditional old school mass tort. And that's what I think people are excited about. Should be a good one. What were your guys' takeaways?
I would agree with the Olympus. It was definitely a lot of buzz. I can say that we have received a lot of follow-up messages from firms looking to get into that one, have a bunch of questions for us.
Everybody was talking about Lanier's presentation. That room was packed. Everyone wanted to know what Mark had to say about the trial. He had some good insights. Kind of teased the Trial Academy coming up to learn about what's next. Other than that, I think it was just updates. People were talking about what happened with Roblox and where that case is going to progress to or not. A few people talking about still trying to deal with their Camp Lejeune dockets. The typical buzz about everything that's kind of currently active. But I agree with you. The Olympus Scopes was huge. Mark and I got to sit down with Kelsey Stokes and talk about it with her. That episode with her, you can click right here above and you can actually watch that full episode straight from Kelsey, exactly what that case is about. Highly recommend you check that out. Her episode that she did with us on hernia mesh 6 months prior at MTMP was one of our most watched episodes. So it's great to have someone like Kelsey leading this litigation. I think that's why there's probably so much excitement. Now that she's with Lanier, you have that firm behind it. It's when you see that much firepower behind a case, that there's something meaningful there. And Kelsey gets in the weeds about, why it's a good case. There is enough instances of use of Olympus branded scopes where it warrants further investigation, I think, from firms to consider potentially acquiring cases and, whether they handle them themselves or they refer it to a firm like Lanier, kind of up to them. But yes, I agree with you. Pre-consolidation, it's been a while since we've seen something this exciting.
I think part of it is, I think people like not the simplicity of it, but they understand it. It's a medical device. There's documented use of it. It's overwhelmingly has a market share, and the injuries are pretty substantial. So I think the fact pattern is simple. It's the old school mass tort way that people understand very clearly. They can understand it, and it's why they get the excitement behind it.
Yeah, that's a great point. It is a little bit simpler, like you said, and it's got the signature injury. So it's not, which of the 20 Zantac cancers are going to survive. Now we're down to 10. It's very clear cut. So I'm sure we'll be talking a lot about that. We'll see if it cracks the top 10 in our power rankings, but I don't know. It's a little early for me for the top 10.
Yeah. Well, we'll see what happens. A lot of progress the past couple of weeks in mass torts. Joe, it's you move a little bit and your lights go on in your studio. I don't know what's going on there. We will see what happens over the next couple of weeks. A lot of news, a lot of trials, a lot of things happening. As always, stay tuned on Tort Talk and catch the best of previous week's mass tort news in just about 10 minutes.